So Mike, I thought this was a very innovative paper, very provocative. Not sure I'm ready to be convinced yet, but so as I see it, there's really sort of two foundations here. One is a claim about the judicial power and a reading of Marbury, and the other one is a claim about the legislative power and a reading of McCulloch. So rather than talk about both of those and go on too long, I'm just going to talk about McCulloch for a second. So as I read McCulloch, and maybe this is mistaken, the claim there is that Congress has a lot of discretion as to the means it uses to enforce, to carry into execution the enumerated powers. I don't read McCulloch or Marshall generally as saying, oh, and Congress has a lot of discretion to say what the enumerated powers mean also. So if you take a look, for example, at Gibbons, Marshall doesn't really say, well, it's up to Congress to decide what commerce means, in the sense that, well, it could mean manufacturing, it could mean, not that all these issues are raised, but that never stops Marshall. It could mean all these things, and it's really up to Congress to decide. No, Congress has the discretion to enforce a power, an enumerated power, that the court seems to think that it gets to decide on the meaning of, even though you could very plausibly claim that commerce and commerce among the states, both of those things are ambiguous or vague. So if that's the McCulloch understanding of things, then you translate that into the 14th Amendment context. It suggests that what Congress has is a lot of discretion to figure out the best way of enforcing what the meaning of equal protection, due process, of privileges or immunities are, as determined by the court, which I take it is something contrary to what you're arguing.
Larry. Yeah, Michael, I always enjoy reading a Paulson paper. It's never dull, always highly original. In this case, the last compliment I might pay, I'm going to withhold for the moment, which is that it's correct, because I'm not certain, and I want to focus right at the beginning, right at the premise, which is the indeterminate text. And you say, by indeterminate text, you say on page 6, it's a provision that can bear a range of meanings. Now that, to me, is an ambiguous statement, because text can bear all sorts of meanings, depending on who wrote them and why. And so and just to elaborate, there are two notions of indeterminacy that might be at work, and I'm not sure which one you're working with. One is an epistemic one. We just don't know what they meant. Those people who wrote it or ratified it and the like. And so we might have a response where we can't tell what someone meant, and we mean it indeterminate in that sense. But I take it that's not exactly what you mean. You have a more, what I'll call, ontological sense of indeterminacy. The there is just not a determinate there. And I didn't see anything in the paper that would convince me of that what those who put the provision in didn't have in mind a there. There wasn't a there. You seem to conclude. You sort of rush from the fact that the language is hard to decipher to this broad power to enforce God knows what. I mean, I wouldn't even know what the boundary was without a description of sort of your sense of what the there is. Anyway, I'll leave it.
John.
Like I knew the rhetoric of the description of congressional power sounded familiar. It sounds like OLC describing the executive power. It's plenary, sweeping, copious, vast, and really huge. But I have a textual difficulty. And the textual difficulty is the form of the 14th Amendment is 4 rules. People usually think about Section 1. 4 rules and a power to enforce. And if you say, here's a rule, and here's a power to enforce it isn't the power to say what it is, it's just the power to enforce it. So it seems to me that what's doing the work for turning the power to enforce into a power to say what it is isn't the text, but rather the theory of judicial review that's about the indeterminacy or not of provisions being interpreted. And if you look at other parts of the Constitution, you see on one side the Treason Clause, which has a rule and a power in Congress to determine the punishment of treason, but quite clearly not to determine what treason is. That's why the rule is there. That's why it's formulated that way. Rule here, power to enforce there, quite separate. Whereas the Full Faith and Credit Clause is different. It's got a rule, but it then gives Congress more power, saying Congress may prescribe the effect of the Act's proceedings and records, which is traditionally, and I think reasonably interpreted, as creating actual substantive discretion in Congress. But it seems to me that the 14th Amendment structure is the Treason Clause structure, rule enforcement, not the Full Faith and Credit Clause structure.
Mike, want to take a try and then let Earl get in, and then we'll take a
First,
second try.
thank you for all the left-handed compliments. Innovative and provocative. In Minnesota, when someone says, well, that was different. But I'll construe it generously as actually intended. Earl, I appreciate your comments too. I'm going to mention some years in the context of responding to Michael, Larry, and John. Michael says McCulloch is about broad choice of means to effectuate a power, but the determination of what is the meaning of the power is the courts. I think that's a fair enough reading of McCulloch, but look what the effect of McCulloch is. Given that the meaning of commerce, and especially necessary and proper, bears a large range, McCulloch affirms a sweeping grant of essentially interpretive power to Congress to choose its choice of means, and grants them a lot of discretion. Now, with the 14th Amendment, you have that sort of McCullochish understanding, and it's actually built into the text when they say, Section 5 to enact appropriate legislation. They're mimicking McCulloch and the McCulloch understanding. So you have the broad understanding of means to enumerated end. But on top of that, you have a very broadly worded enumerated end. Enforce prohibitions on state denials of privileges or immunities, equal protection, and due process. To whatever extent the language is indeterminate, and I'll come back to that in just a second, to whatever extent the language is indeterminate and admits of broader readings, you have the McCulloch power, which gives a broad means and power, operating on a provision which is itself quite general and indeterminate. So you have kind of like the necessary and proper clause on steroids. Now, you say, but isn't that a power to enforce the interpretation as determined by the court? I think that's a premise of judicial supremacy and constitutional interpretation, and some of you who are familiar with my other work, I just don't buy the premise of judicial supremacy and interpretation. And it seems to me from the history and from the text of 14th Amendment that the adopters of the 14th Amendment, 9 years after Dred Scott, are not buying into the premise of judicial supremacy and interpretation, and deliberately wrote a constitutional provision that would put the lion's share of interpretive power in their hands. But that's a disputable historical point. Larry Alexander questions the idea of indeterminate text and uses, I'm just a kid from a small town in northern Wisconsin. Epistemic and ontological, I don't even know if I have them spelled right here, but I think I understand what you mean. Epistemic, we don't know what they meant. Well, this is a long-standing disagreement, Claire. It's not necessarily what they meant, it's what the words mean objectively. But putting that to one side. Oh, wait. That's tomorrow's papers, right? Okay, we'll postpone it. As opposed to the ontological, the there there ain't there. Okay. I think it's really some of both. Okay. To some extent, we are uncertain of the range of meaning the drafters intended or that the text actually implements. And there's a range of uncertainty that corresponds to that. To some extent, also, we don't know what it means, at least beyond its core determinate meaning, because at least as as sort of an amateur on this, read the historical evidence, the language chosen was to some extent chosen to paper over disagreements as to just how far it would go. So that they, left it as kind of a universal player to be named later clause. Senator Howard is pretty explicit in saying that.
Explicit, that's
No. Okay, I'm totally wrong. But let me just assert that as my position that that some of the indeterminacy is epistemic, and some of it is ontological, and I'm not sure it makes any difference. There is a there. My premise is there's a determinate core, but then an indeterminate periphery. The indeterminate periphery is what gives rise to the broader congressional power. The determinate core is what the courts can enforce as law, and there are going to be arguments about where that line is and where the penumbra is bright and where it's really, really fuzzy. John Harrison, my old boss at Office of Legal Counsel. But this reminds me of an argument we used to have over the Free Exercise Clause, which John interprets it is a rule about the substance of rules, and I said, no, it actually grants a substantive liberty. John says the 14th Amendment is a series of 4 rules and a power to enforce. Which all makes me think about, what is the content of those rules? Okay, what is the content of those rules? To the extent the rules themselves are indefinite, I think that lessens the power of the judiciary to enforce them as rules of law. To the extent that those rules are indefinite and coupled with a power grant, I think that gives Congress broad authority to instantiate those rules more definitely in the policies that it chooses. I think it's a great point about the full faith and credit clause being an especially plus power. I don't know whether this is like the treason clause, definition plus power to prescribe a penalty or not. It strikes me as something different. It strikes me as more like the McCulloch power and more like the Section 2 power of the 13th Amendment. That's explicitly cloned language when they get to Section 5 of the 14th Amendment. And in the cultural milieu and the intellectual atmosphere and the legal background principles at the time, when they adopt a provision like Section 5, I think they're adopting a pretty aggressive enforcement provision, which they understand in terms of the power to carry into execution whatever it is that's being enforced. That's the McCulloch understanding.
I would advise everybody that whenever Mike pulls the just a small kid from a small town in Wisconsin to grab your wallet with both hands. Earl, do you want to?
And don't bet against the Packers.
Yeah, just a couple of things. First, I think I'm now going to prove that I have no life. And the way that I'm going to prove that I have no life is I'm going to say that I have a favorite passage from the legislative history of the 14th Amendment. And it is an exchange between Andrew Rogers, who's a sort of foaming at the mouth radical Democrat, and John Bingham. And Andrew Rogers says, well, I don't know what the Due Process Clause means. And Bingham says, that's been decided long ago, and the gentleman can go read the cases. Here's the point. This is sort of the originalist point, which is that we begin with, I don't think Howard, if you're talking about Howard, at this point we're really talking about inside baseball, is talking about open-endedness. I think he is talking about uncertainty at the margins. That is, something can be uncertain at the margins, but nonetheless fixed at the time. Okay? And I think that I don't see anybody who is already saying, okay, guys, let's give Congress authority to just decide what privileges and immunities and equal protection due process are. I think they are using relatively well-established legal terms which are uncertain at the margins at the time, which leads me to my vision of originalism, which leads me to the question, which is related to the question of who decides. It seems to me that the question of who decides should probably be a question of institutional competence at some level. And here is my version of originalism, and I know it's not Heidi's version of or what Heidi's talking about tomorrow, or Larry's version of originalism. It is that the language should be interpreted as the hypothetical neutral judge at the time using available legal documents would have applied the language to the facts based on all the facts that he would know now. Okay? So it's not, and that's obviously quite different than what I wrote 20 years ago, but now I'm senile. But so it's not intentionalism, and it's not Randy Barnett public meaning. It's what I think of, even though I'm not an expert on Blackstone, as something like what Blackstone said. And if that's the version, and given that version of originalism, it seems to me that judges have institutional competence to determine the basic meaning of the clauses. Now, but that still doesn't answer the question about Section 5, because in dealing with Section 5, you still have to deal with the available legal materials of McCulloch, right? So that, I take the point that, I take both of your points about the range of McCulloch, but given that the existing legal documents established a fairly large set of rights for, in particular, privileges and immunities, as John has discussed so wonderfully. That if you take that and you put that together with McCulloch, you have a pretty broad authority in Congress. But that gets back to this question of if they didn't want it, but to them at the same time saying they didn't want to change federalism that much.
Two real quick points. Okay. I do have a life, so I hadn't read the Bingham exchange, but I will. I'm rapidly losing my life as I dig into the 14th Amendment history. But actually, it's a very interesting reference that, you can go look it up in the cases. Some of the provisions of the 14th Amendment that liberal interpreters tend to view as radically open-ended actually were term of art meanings that had been to some extent liquidated by judicial decisions, and it does appear to me that the legislative history references those increasingly settled meanings. I think when you adopt a clause at time 2 that had been in a previous legal document in time 1 and received authoritative constructions or constructions that people had come to treat as authoritative, that actually gets incorporated in as a term of art meaning of the word privileges or immunities, and certainly that does reference to some extent Article 4. There are references to Corfield Court versus Coryell and things like that. That doesn't settle all interpretive questions. The other quick point is, I think in the end we don't disagree probably very much as to the range of meaning as to which, Earl and I, as to which provisions are determinate and which ones aren't, and as to the range of determinacy. But I think we do have a difference of belief as to constitutional competencies. By that I mean, not who's particularly good at constitutional interpretation, but in whom the Constitution vests interpretive power. My theory has always been that it invests interpretive power in all those called upon to exercise power under the Constitution and swear an oath to uphold it with respect to whatever functions they perform. So Congress always has had a power of constitutional interpretation, and constitutional competency in the constitutional sense. Whether they're particularly good at it or not is a different matter. I'm not always so sure the courts are particularly good at it either. But Section 5 seems to be, and I think we're in agreement here, a specific grant of enhanced constitutional competency to Congress to implement the meaning of Section 1.
Our next right, actually, the conversation has induced me to put myself next, and then Myman and Hannah Volok. My point is about rights and remedies, and one of the vexatious things about the 14th Amendment is it occurs during a transition from legal thinking about rights as the court you go to for a particular form of action, a particular kind of relief. Your rights are defined backwards from your remedies. By the time you get to the 1890s, the early 1900s, by Holmes, The Path of the Law, Wigmore's Treatise, and that sort of thing, Bentham and Austin have saturated things pretty deeply, and rights are abstractions. And if the legislature has declared an abstract right, well, then you start hunting for remedies to enforce that abstract right. And the problem that you have with the 14th Amendment is it's right there in the middle of that transition, and different people are coming to that modern way of thinking about the lexical ordering of rights and remedies at different times. Myman.
I actually thought Michael's suggestion's an attractive one, which I really mean as a right-handed compliment. Though as a very clumsy person, I've always wondered whether there ought to be a new category of being ambi-maladroit. Directed at me, not at Michael. Michael says this is a radical critique, and I wonder to what extent this is a radical critique not just of relatively recent constitutional history, but running all the way back to Marbury itself. It's notorious that the constitutional provision that Marshall purported to be construing in Marbury, namely the idea that the Article 3 gives appellate jurisdiction at most rather than at least to the Supreme Court, that provision was actually a lot more indeterminate than the hypothetical parallels that Marshall gives in Marbury itself as examples of what it would clearly be outrageous for Congress to do. Marshall cited John's treason clause, that, suppose Congress made treason provable by one witness, or suppose Congress enacted the Ex Post Facto Act of 1802, that in fact the actual provision that Marbury was construing was much more indeterminate. And that suggests that American constitutional history, running all the way back to Marbury itself, doesn't take a minimal interpretive approach to broad constitutional phrases, nor, therefore, a broad grant to Congress to interpret. Now, I suppose one possibility is to say that Article 3 is less indeterminate than the 14th Amendment, or to say that it's not a grant of congressional power, though of course it is, at least explicitly, with respect to the power of Congress to establish lower federal courts. Or I suppose you could say that Marbury was wrong, and you wouldn't be the first to do that. But it seems unclear how Marbury and the constitutional history that it initiated fits into the suggestion that the paper makes.
Let me take these in reverse.
We've only got two.
Okay.
Hannah.
Oh, good. Sorry. Oh, no, good.
Your response. I thought your paper was fascinating, and I am particularly interested in Congress's role in this whole scheme because I have always been a big supporter of Congress's authority to interpret the Constitution, but possibly not as big a supporter as this paper reveals you to be. It strikes me that there are at least three ways that Congress can go about interpreting the Constitution, three things that we might call Congress interpreting the Constitution. The first one is for Congress to explicitly disagree with the Supreme Court's interpretation of something, or to act prior to the Supreme Court to interpret a provision and say, this is the way we think that the Constitution should be interpreted, and we're encoding this in statute. The second way is to pass a statute and try to justify that statute within existing Supreme Court doctrine. So they might say, it's unclear, but here's why we think that our statute fits within what the Supreme Court has said. And then the third way is if Congress just doesn't care or doesn't give any discussion to the problem, you might still say that just by passing the statute and putting their stamp of approval on it, they have implicitly certified that it's constitutional, even if no one was even thinking about the Constitution in the course of passing that statute. Maybe they didn't care that it was constitutionally problematic. Maybe they didn't notice that there was a constitutional issue going on with the statute. So my question is, when Congress passes statutes through each of these methods of discussion, do all of these count equally as interpretations? Are all of them competent interpretations of the 14th Amendment? Does this make a difference to what you're talking about?
That's a really good question. Okay, now I'm going to work backwards. I think in my scheme of things, it doesn't make a difference. It doesn't. I've always found it strange in Supreme Court jurisprudence, but it's not strange that I'd find Supreme Court jurisprudence strange, that they would often view whether Congress has a power or not in terms of whether or not they claimed that they had that power and made findings pursuant to that power and invoked the right power. I think if Congress has power, it has power regardless of whether it used magic words, da-da-da, here we are using the blank power. So that if Congress invokes a wrong power to justify what it has done, but it has power under some other provision, it has power. If Obamacare's individual mandate is a tax, and if it is constitutional as a tax, it does not, to me, matter that President Obama said, oh, no, this is not a tax. Okay, I think you don't waive the existence of constitutional powers. So I agree that it is implicit every time Congress passes a law that is making an assertion that it has constitutional power and that it is an act of interpretation, whether it is overt or not. So that doesn't distinguish these two. Obviously, as a tactical matter, it will often say, look, we really do fit within judicial decisions so as to minimize a direct head-on conflict. I can see the political appeal of doing that. I'm usually not a minimize head-on conflict kind of guy. I'm kind of like looking for maximum head-on conflict, just as a matter of principle. It's what used to drive my bosses crazy at OLC, right, John? And so I think where it explicitly disagrees with the Supreme Court interpretation, I think that's a desirable thing. The interesting thing about City of Bernie, which struck down RFRA, the Religious Freedom Restoration Act, is, that seemed to draw the court's particular ire. If you read the decision, it's mostly about affronted judicial dignity. We issued a decision, you explicitly disagreed with our analytical framework and passed a law pursuant to that effect? Shame on you, we are the bosses, we are judicial supremacy. Okay, I think that's what cast the law, what led to the law's downfall as a constitutional politics matter, and I think that's regrettable. But in terms of whether Congress has interpretive power, it doesn't matter what they say in the course of exercising it. Hang on. Yeah, Marbury is wrongly decided. Okay, I got a footnote buried in here somewhere. It's like in the early teens. I don't know. I've revised it even since I sent out the draft. That one of the ironies of Marbury is that this principle that you can, the power of judicial review presupposes a rule of law. It's fine. Part of the irony of it being in Marbury is that if constitutional provisions have a fair range of meaning, the question of whether you can enlarge the original jurisdiction of the Supreme Court and whether the grant of original jurisdiction is a baseline or a maximum would seem to me to be one. I think I've said that in an article snottily entitled Marbury's Wrongness for a 200th birthday party for Marbury. So Marbury is wrongly decided. That doesn't mean the interpretive principle as a rule is wrong. Okay, I'll concede that there's been a lot of judicial practice going way back that's inconsistent with some of these stated principles. But I'm just looking for what I think are the right principles. Some of that is defended in early judicial doctrine, and sometimes the courts depart from principles. That's not particularly shocking, to me at least. Don, I take your point. I don't know this point very well about 1890s, and changes in legal conceptual framework and rights as abstractions. And I'm inclined to believe you that, the 1860s is a transition point in that conception. But I think I'm just going to ask a question of the question. How does that affect my thesis?
If rights come first and remedies come second, John Harrison is right. If remedies come first, enforcement comes first, and that's what you have rights to, then you might be right.
Okay.
I see the point. But, Earl.
By the way, I forgot to mention that I thought that Mike's paper had a nice personality. But
Cooks up a storm.
It seems to me that I'd like to make what I think is an important distinction. Might be that some of you might think is a distinction without a difference. I think that individual members of Congress, probably in good conscience, should decide if a particular statute is constitutional or not. I'm voting for it. I'm not sure what we're asking the question once the statute is adopted about whether Congress has interpretive power or not. I wish I had a blackboard sort of thing. That it seems to me that the court decides what the bounds of congressional power are as an interpretive matter, and it doesn't matter whether Congress is interpreting the Constitution or not. The only question is whether the statutes are within those bounds of interpretive power. I think that makes a difference analytically. I'm not sure how much difference it makes in the real world. So I'll shut off.
I think I agree with that.
Cypher Kosh, Bernadette Myler, Rick Kay.
As I do all of your papers. So I'm wondering how this fits in with what you've written elsewhere about presidential power, right? The necessary and proper clause says that Congress can carry all powers of the federal government to execution. Let's assume, and I think you'd have to admit this, the executive power is indeterminate at some level. Congress passes a statute saying that the president can't suspend habeas corpus. Mike Paulson thinks he can. Does Congress win because Congress has this interpretive power under the necessary and proper clause? Because I take it your point isn't just that McCulloch established some broad conception of the necessary and proper clause. I think you think McCulloch is right, and if you think McCulloch is right, it doesn't really matter that they passed the 14th Amendment with this interpretation. And if that's true, then why doesn't Congress just get the power to say, whenever there's an indeterminacy, what each of the powers of the federal government are and aren't?
Who's next?
So
Bernadette.
I think this might refer back to some of the earlier questions, but I guess I'm curious as to whether you think that indeterminacy is really necessary or sufficient for your argument. I mean, it seems like you're making two different points that then are being connected. One about the indeterminacy of the text, and then the other about congressional powers. And I'm just not sure I yet see exactly how they're tied together. And so I guess on indeterminacy, it seems like you could either mean that there's a range of meanings that are plausible, or that there's no meaning. I would assume you mean the first. So to the extent that you mean that there's a range of meanings, I think that then you don't get where you want to go necessarily with the broadest range of congressional power. So then if you are saying that Congress could go further than the available range of meanings, then that seems to be relying more on some independent congressional power that might be connected with McCulloch or with the necessary and proper clause. And then I would sort of get to the point that Mike was making earlier about, is a means for effectuating another power really the same as enforcing a particular provision? And so I guess I'm just wondering about the connection between the indeterminacy and the congressional power, and whether you could just rely on your vision of congressional power rather than indeterminacy at all in the paper.
Rick.
I like the paper. I really enjoyed it. On the question which Bernadette was just asking about, and other people have about legislative power and McCulloch, I'm kind of okay with that. I see where that's coming from. I guess the more troubling part to me is the other part, but the kind of judicial part. And I suppose I'm bothered by the same thing that I think Larry was bothered by. It has there's a certain kind of counterintuitive quality to the idea that because the 14th Amendment states a very broad prohibition on state conduct, that therefore it turns out to translate into a very narrow limitation on state conduct when we get to judicial enforcement. So the question is kind of where does that come from? One answer is well, even though the language is broad, they really meant something narrower. Of course, people have said that. There's been some reference to it today. But as I understand it, that's not what you think is the determinative in terms of interpretation, and kind of we're interested instead on the plain meaning, so that the plain meaning of the text being rather broad, we are kind of reduced to a sort of a Thayer philosophy of judicial interpretation. But where does that come from? I mean, isn't that something that comes from outside the Constitution, not itself being an interpretation of the Constitution? So the question is this question of the courts in that indeterminate periphery. Congress has great power, I see that, but the courts have no power. I just don't know, the source of that rule and in what way it's in itself an interpretation of the Constitution.
Wow, great questions. I'll work in reverse again. Now, Richard, that's a true compliment that it's counterintuitive. Thank you. It is counterintuitive within the modern conceptual framework that we're mostly accustomed to, those of us who don't live in the mid-19th century, of viewing constitutional questions as primarily judicial questions, right? That's how we're schooled. That's what they bludgeoned into us for 3 years of law school. That's what we do and we teach. We're habituated to viewing constitutional issues primarily as judicial questions. And I think that's an assumption we have to get out of, right? I think that my argument here is that the text, the original understanding, the structure and logic of the 14th Amendment actually suggests that conventional understanding, at least with respect to the 14th Amendment, is just flat out wrong. Okay, it's upside down. Actually, that shouldn't be that counterintuitive if you've immersed yourself enough in the 19th century stuff. Because at the time that they're writing this, they are not big fans of judicial supremacy. That's what who was the last interpreter of privileges and immunities and substantive due process? It was Roger Taney and Dred Scott. At the time they're debating the 14th Amendment, they're hot and bothered about ex parte Milligan, which they perceive as judicial intrusion into Reconstruction. These are not judicial supremacists who are drafting this text. And it really is quite ahistorical to impute to them that sort of modern understanding. But as to your question about where does the idea of that the judicial power is small with respect to indeterminate text come from? Okay, where I still need an independent justification for that, and I've built this in part as you kind of need second order institutional rules about who has interpretive supremacy, right? And those independently have to be justified, right? So really, you're right. At some level, it is an interpretation of what is the Constitution's meaning with respect to the judicial power. Okay? What is the Constitution meaning with respect to the judicial power as applied to indeterminate texts? And does the judicial power permit courts to set aside enactments of legislatures that are not contrary to a determinate rule in the text? Okay. So you're right. In itself, that is an issue of constitutional interpretation, on which I think we should search for the original public meaning. I think Marbury's stated principle has that exactly right, and that's kind of where it comes from, that in McCulloch. Bernadette, is indeterminacy necessary or sufficient for my proposition? I'm going to use this to kind of sideways hit Cy Prakash at the same time, or at least warm that one up. If there's a determinate legal text, like the example everybody uses, though an imperfect one, is president has to be 35 years of age. and Congress has power to enforce a really determinate text, okay, then the scope of its power to enforce or to act on a determinate text is correspondingly reasonably narrow, okay? So that a lot of what does drive my theory is the premise that within at least within a certain range, the provisions of the 14th Amendment, Section 1, are indeterminate. So indeterminate is necessary to give you any sort of significantly enlarged congressional power. You're right, and I think I should separate this and make it more clear in the paper. The McCulloch power, a power to sort of augment or go beyond, is a little different from just the idea of interpreting an open textured provision. So I kind of have a double weapon, and I think in my text so far I've kind of smooshed them together, and I think it would benefit from my making clear that, hey, I've got two swings here. You know, I'm hitting you twice. Cy, you always do this. I was like thinking today as I was running, you know, what is Cy going to ask me? Because he's going to get me. You got me dead to rights again, I think, but I'm going to try to wiggle out of it. If the meaning of executive power is in certain respects indeterminate, okay, then I think Congress does have a legislative power to enact legislation necessary and proper for carrying into execution the executive power, and you're going to have inevitable pushback from the executive as to exactly how determinate the meaning of the term executive power is, as opposed to how indeterminate it is. Now, schooled by John Harrison and John McGinnis, and by Sai Prakash, I've done a lot of thinking about executive power, and I tend to think it is not that indeterminate in the constitutional text. But that's a separate argument we can continue to have. Whatever the range of indeterminacy, okay, I think the necessary and proper clause, properly construed, can act on that, okay? And I think this disagrees with your view. I think the necessary and proper clause power, well, you know, I'm going to leave it there because there's a side issue as to whether the necessary and proper clause power can be used only to augment, you know, to carry further into execution, or whether it actually can be used to hobble. And I think in some ways, remember I floated around this Judicial Activism Abolition Act? We were talking about being co-authors and all that about 8 years ago. Still haven't settled this. I tend to have a view that the necessary and proper clause power could be used to shackle just a little bit, and that's, I think, why we ended up not being co-authors on that. But I think that's a side dispute. Whatever the sphere of indeterminacy of a given clause, and this goes to Bernadette's point, that gives you the more interpretive leeway as a legislative branch if you have the power to enforce or to carry into execution that particular constitutional provision.
Roll something quick. Can I go 4? Bob Bennett, Larry Solom, Kurt Lash, Stanley Fish, and let's be terse because we're out of time.
How do you get to the proposition that a part of the core meaning, judicially enforceable, of the Equal Protection Clause is no discrimination on the basis of caste? I could ask the same question about how you get to the proposition that part of the core meaning is that you can't discriminate against descendants of slaves. I could even ask the question about slaves or ex-slaves. But I can imagine answers from someone of your frame of reference to the second and third of those. I'm quite bewildered about how you get to the first of them, caste.
Larry.
Tersely. And I want to just say I did really like the paper, right-handed compliment, and I think that the core of your conclusion is correct. If I can offer some assistance on just, I'll email you because I have a bunch of things, but if I can offer your assistance, I think many of the comments that you've heard really require you to much more richly develop the part of the paper that defines what's in the core and what's outside the core. That is, what's determinate and what's, I would say, underdeterminate. So the first thing I think you need to do there is just get real clear about whether these are terms of art, or more properly, phrases of art, or not, the Section 1 provisions. If they're not, then, you know, I think it's going to follow that the zone of underdetermination is very large. If they are terms of art, then you're going to have to fight that out in terms of the history of the specific phrases at issue, and that's going to be a complicated enterprise, and it's going to complexify the paper considerably. And once you've done that, then I think you want to talk about whether the underdeterminacy you're talking about flows from ambiguity, or from vagueness, or from open-endedness or open texture, if there is such a thing. And if, you know, all of that needs to be worked out, because currently you have all that kind of mushed together into just a few sentences of argument that are highly conclusory. And once you unpack all of that, I think that the rest of the paper will work better. And I wish I were not in the terse part of the comments, but I will email you with the rest.
Kurt.
Kurt Lash from Illinois, since I didn't have a chance to introduce myself earlier. I enjoyed the paper very much, and you know that I've commented. I've sent you some of my comments. It seems to me that you and Earl there's a lot of agreement there. The disagreement is simply the range of meaning that's available, right? You've made some broad assertions about broad meaning, but maybe it's more constrained. Maybe the range of meaning is a little less. But your point, your institutional point, I think is still going to remain. It's kind of what Larry was talking about, that at some point there's going to be a range of underdeterminacy. At some point there's going to be some degree of flexibility, and then comes the institutional point. Is it left to Congress to determine that, or is it left to the courts? I think this is a new question that you've opened up in terms of originalism that I haven't seen stated this way before, or focused on, the meaning of Section 5 powers. Was it understood in a McCulloch sense? And if it was understood in a McCulloch sense, what was that sense? Because I think there were disputed meanings, disputed assertions about what McCulloch meant. I don't think there was one particular meaning. And then as you develop this, and I know you're developing your historical section, you are looking backwards and making institutional claims because Dred Scott looms, right? They're not going to be judicial supremacists because look at what's happened in the past. I would simply encourage you to also look at what was looming in the future that might complicate the picture, and that's the return of the Democrats. I think that you can find in the debates themselves, you can get this in Hotchkiss and others, who talk about how if the Democrats come in and take over, they might interpret their powers in a way we would very much disapprove of. So they were at least aware that there might be a different political party in power. How might that complicate your picture? But again, I think it's a great question, and I like what you're doing with it.
Stanley.
I'm not competent to talk about the issues of executive power or the meaning of Section 5 powers. When I sat down, and Larry Alexander sat down next to me, we immediately and looked at your, can I call it, little yellow-orange sheet. We both circled the same word, which was indeterminacy. And for some of the reasons that Larry Solom suggested when he said that there are things there that should be worked out. I'm afraid they could not be. Indeterminacy or determinacy as notions are parasitic on textualism. That is, it's only if you are a textualist, as I know you are both from this paper and your other writings, that you can begin to talk about determinacy or indeterminacy of language. Because if the text is available as a text, independently of intention, can you then say about it that it is vague and open-ended or determinate and clear? Now, since it's my view, and the view of at least two or three others around the table, that you can't say that something is a text or independent of intention, the notions of indeterminacy or determinacy, if you are applying them or thinking about them in text, just don't work. I would go so far as to say there is no such thing one of my favorite phrases. There is no such, yes, many. There is no such thing as a determinate or an indeterminate text. And I would go even further, and I'm going to stop here. There is no such thing as a language. All of the arguments around the table, which depend on some account of the meaning of words, is going in the wrong direction, which is precisely what Fuller said to Hart in that famous debate, which we are still living out, about that wretched example of vehicles in the park.
These are great. I'll bullet through. Okay. Professor Fish, the issue is joined at that point. I think you're right. Is that my premise is.
Well said.
But my words have no determinate meaning apart from my intention. And what I actually intend is to continue that debate tomorrow in the context of Heidi's paper, where I will, I'm not enough of a philosopher to be able to engage with you and Larry on these sort of things, but it seems to me that sometimes intention, especially when we're talking about law and texts put together by a collective group, that intention is going to be indeterminate or determinate too. This goes to I think to Bernadette's point as well. But you're right. I have to start from the premise that there's a text in this course. For actually Kurt, Larry, and Bob, you all have me dead to rights. This is the part of the paper that isn't finished yet. The rubber hits the road at the point of, okay, Paulson, what is the determinate meaning? Or give us your authoritative core irreducible meaning of the first of section 1 and justify why that is in the core and why the other is in the periphery. Another level at which it occurs is, okay, Paulson, tell me what is the full outer bounds of the range of allowable meaning, okay? And to some extent, it's just like I haven't done all the work yet. But another point, I want more feedback on that, is I'm wondering if this is, sort of 2 papers or if it's going to be one of these long, massive papers that nobody ever publishes because it just takes up too many pages. Because part of me is tempted to sort of bracket out the issue of the meaning of any one of these provisions and just sort of make an argument about the effect of indeterminacy, if there is indeterminacy in the meaning of the 14th Amendment, Section 1. Okay, just make the pure institutional point. I'm just inclined to go too far and to try to answer all questions of the meaning of the 14th Amendment. I have tentative answers, but I don't have them worked out yet. Michael, I don't think this one is going to appear in a law review next year. I think you're going to have to invite me back next winter for a follow-on once it's more fully thought.
Can I just make 2 or 3 brief comments? First, on Bob Bennett's comment, I think caste legislation is itself a term of art at the time, and it has to do with the not having the basic civil rights. And that's not about discrimination per se. It's what I describe as limited absolute equality. And it's what John Marshall Harlan actually said, rather than what he's quoted, what he's normally cited as saying, with respect to civil rights common to all, was it citizens common to all persons, we know no caste, that everyone has a certain, that caste legislation means that you have to have a certain core of rights. With respect to the question of, to comment on Kurt's point, one of the problems, it just actually occurred to me today, that one of the problems of the translation between the original Bingham language and Giles Hotchkiss is probably maybe the most obscure member of the 39th Congress. I mean, he doesn't, and by the way, he also agrees with the other people who say that the language is too broad, in addition to saying the other thing, as I know, I can tell you know that. But the problem is the original Bingham, it just occurred to me, the problem is that the original Bingham draft is a pure sort of independent federal power draft. The final version of the 14th Amendment is actually a peace treaty, saying that if you want to get back into the Union southern states, you, particularly with respect to Section 1 and Section 2, you have to accept the modifications of the original compact. And I've started, Section 2 is really important about this, actually. But Section 1 says you have to pledge, before you didn't have to pledge to agree to any of these things, to enforce any of these rights. Now you have to pledge to give all free, since there aren't any more slaves, all people a certain core of rights. So and that translation creates a problem because now the Section 5 part is separated out. I haven't quite worked out the implications of that. With respect to Stanley Fish's point, I would say I'm actually not talking about trying to figure out the meaning of the text. I am talking about how judges should act given the existence of the text. And that's a different thing. And they should look at the text and say, given the existence of the text, we are invited, in my view, which is obviously the right view, that we are required to enforce what the meaning of this language would be given the existing legal context. But I'm not talking about the abstract meaning of the language.
More could be said, and we have excellent people still on the queue, but Justice Holmes once said the trial's end is a concession to the shortness of life. And now that we've settled these issues, let's take a break and come back and settle some more in 15 minutes.